Dr. Kimeu Boynton, how are you doing tonight or today?
Doing well, doing well.
5:02 a.m. in Delaware or DC, wherever you are.
Yep, Delaware today.
Okay. Um, Thanks for coming in today. You're an associate dean at Delaware State University. Really appreciate this. What do you want to talk about today?
Today, I'm going to talk about a little-known civil rights case in Delaware called Parker versus University of Delaware. It was sort of a case that kickstarted the school desegregation cases following with Brown versus Board and those companion cases. So um, I can go ahead and get started if you'd like.
Sure, that'd be great. And I'll tell you that in 2020, one of the things we do at Common Power is we do early presidential primary trips where we take folks to see the candidates because you can get pick up to talk to them early in these early states. And we were in South Carolina and Joe Biden was there. And I saw Joe Biden and Jim Clyburn together. And they talked about, and Biden and Clyburn talked about how they used to sit and talk about the Briggs case in South Carolina and the Parker case in Delaware. And then I went off to read Simple Justice, which links all these cases together. And so I'm looking forward to this, and I appreciate you bringing this today.
No problem. I appreciate you guys. And I'll just say quickly, being part of your past trip through Georgia and Alabama was a great experience. And I've connected with all of my cohorts from the trip. And I appreciate what Common Power is doing.
Thank you so much. Actually, I need to mention one more thing. You also connected us with a leader, a community leader in Philadelphia that our folks, our team got to meet with a week, just 5 or 6 days ago. So you have already been a good partner for us, and we deeply appreciate it, and we're looking forward to more. So I'm getting out of the way now. Okay.
No problem. Thanks, David. All right. Yeah. So wanted to talk about this case, Parker versus University of Delaware, and how principally individuals engaged in civil rights litigation had to really come up with novel ways to sort of address some of the discriminatory practices that were in play, principally in the time of Jim Crow. Starting off with Plessy versus Ferguson, as I think Dr. Scott and Dr. Williams talked about at the very beginning of the teaching. The interesting thing about Plessy is that the Supreme Court did acknowledge that separate but equal should have been absolutely equal between the races. But also interestingly, they also said that there was no intention on bringing people together based on color or any other commingling of the races whatsoever. So they have this idea that yes, there should be absolute equality, but no, we're not going to force states to put individuals together based on based on their skin color or other factors. But when we think about absolute equality, what does that mean? And so essentially, we have to decide if there is no absolute equality, then that's going to lead to some disparate treatment by one race forced on the other. The dissenting opinion in Plessy basically said that the Constitution was colorblind, right? And all citizens should have equal access. But let's take a look at Delaware itself during Jim Crow. In this graphic here, this particular picture, this almost looks like a lynching photo, but in fact, this is the whipping post, which was located in all 3 counties in the state of Delaware. The last time the whipping post was used was in 1952. The vast majority of individuals who were punished by the whipping post were African-American state citizens. And most of the punishments were for petty crimes like petty larceny. But I put this picture up here to show that this sort of public flogging was very common, particularly for African Americans during the Jim Crow time period. And for us to look back and say, well, 1952 was the last time someone was publicly flogged in Delaware, it's amazing to think that we're only 2 years away from Brown versus Board when it was last employed. But the Jim Crow laws in Delaware were a direct result of the Civil Rights Act of 1865, and the Delaware legislature immediately decided that they were going to pass a law that would segregate individuals, or I should say empower owners of theaters, restaurants, hotels, or other establishments, give them the ability to refuse service to someone based on their skin color, under the guise that separate but equal was okay. The law was not repealed until 1963.
I'm still seeing your title slide right now. If I don't know if you
did it move?
No, it didn't move.
All right, let me yeah, it's moving on my end. Let me see.
Yeah, then we see the one with the whipping post.
Okay. Do you see, is it moving now?
Yep, higher education in Delaware now.
Okay, perfect. So anecdotally speaking, in 1957, the finance minister from Ghana, a newly independent African country, visited Delaware State University. And when he and his secretary went to a local restaurant, they were refused service. He couldn't believe this, being a visitor and a diplomat from a foreign country. He couldn't understand why he was being refused service. But this was the law in the state of Delaware in 1957. Higher education in Delaware was also segregated. At the time, there were 2 principal colleges in the state: Delaware State College, formerly the Delaware College for Colored Students, founded in 1891. It was a Morrill Act land grant institution. And then there was the University of Delaware, founded in 1834, also a land grant institution. As you can tell, or as one would assume, the Delaware College for Colored Students relied heavily on donations from entities like the DuPont family, whereas the University the University of Delaware had a pretty large endowment and had been supported for most of its time by the state. In 1948, 10 African-American students who were studying at then Delaware State College decided that they wanted to apply to get their degrees at the University of Delaware, based on the idea that the facilities and resources were in fact inadequate at the Delaware State College. And so they applied and they were denied their applications even being reviewed, in some cases for things like they didn't pick a major. But in most cases, it was just that there was already a school that you could go to if you were colored, in quotes, and so there was no need to seek a degree at the University of Delaware. But again, the school for those, and I'll use quotes again, colored students, was wholly inadequate in terms of facilities and resources when compared to the flagship institution. And so looking back at that Plessy case, we can clearly see that there was no absolute equality as envisioned by that majority opinion in Plessy. And there were other state cases, Sweat v. Painter, Missouri ex rel v. Gaines, where states had also said, well, you know what, we don't have a facility for African Americans either at all or one that's equal. And the Supreme Court had said, you know, you have to then offer admission to those students who are African Americans into those predominantly white institutions. Now, the University of Delaware was not so gracious as to just say, well, since the facilities at Delaware State College are not adequate, since the resources aren't there, we'll just let you in. In fact, in 1948, the Board of Trustees passed a resolution where they basically tried to codify a policy that said, if you can get the same degree or take the same courses at another school for colored students in the state, then the University of Delaware would not admit an African-American student. In 1950, they passed another resolution where they basically said the litigants under Parker, the folks that were trying to get admissions, did not fall within the scope of the 1948 resolution. So they basically told them to go away because they didn't feel that they fell within the 1948 resolution where they would have admitted them if there was no other course of study. I'll just take one step back to Plessy for a second as it relates to absolute equality. Harvard professor Kenneth Mack, in fact, said Plessy versus Ferguson did not establish separate but equal. It only gave the government the ability to acquiesce to what was the racial customs of the time, which would last, again, almost another 80 years. Pioneering attorney Lewis L. Redding, who was a legal giant amongst his contemporaries, including Thurgood Marshall and Jack Greenberg, decided to come up with a novel idea of addressing this discrimination on the part of the University of Delaware. And he had been involved in many areas of civil rights. He was the first African-American to be admitted to practice law in the state of Delaware. He was a Harvard-trained attorney. So clearly, he had the bona fides to represent these students. His idea, among other things, and this was very novel for the state of Delaware, was to use the state's chancery court. And a chancery court is a court of equity. It comes out of English common law. Only 3 states have them. And it's where you can basically sue someone for a obligation that is due you. And so this equity issue could be resolved in the chancery court, unlike other courts that are simply going to deal with a basic right that you may have. The equity court is empowered also to hear constitutional issues. And so Redding sued the University of Delaware in the chancery court. And the question at hand is, was the University of Delaware entitled to refuse these plaintiffs admission to the arts and science undergraduate school because they are Negroes and the State College for Negroes exists in Delaware and offers courses leading to the degrees which they seek? So do they have the right, in fact, to discriminate against them because there is another similarly situated institution? And the Chancery Court had to answer this question. The arguments that the plaintiffs put forth was that the University of Delaware, in denying their admissions, really was violating that separate but equal clause, right? That if you're going to have a separate entity, it has to be absolutely equal. In this case, it was not. And we'll get into why it was not in a second. And they also used the sort of theory that the majority opinion in Plessy used in arguing that the schools were not absolutely equal. The University of Delaware, on the other hand, argued that the complaint did not represent a class action. And in fact, the Chancery Court would find that a class action is implied because you could be talking about future applicants who were African American, and that would represent a class of individuals in the state who were being denied a constitutional right. They also argued that the Fourth Amendment had no application because they were not a state entity. And the Chancery Court again found that there were enough touch points to provide the fact that this was a state entity. Their trustees were in fact appointed by the governor. The governor himself at the time was an ex officio trustee. They went before the state legislature for their budget and finance requests. They were a land grant institution. So there were a lot of things that made them a state actor. And then lastly, they said that the litigants failed to give any evidence to provide the fact that Delaware State College was in fact unequal. Justice Collins, yes, go ahead.
We're going to probably have to jump ahead to the outcome here.
Okay, gotcha. So Justice Collins cites, in fact, wrote the opinion stating that the University of Delaware did in fact discriminate on the basis of race, and that they violated the Fourth Amendment rights to equal protection. And he used the idea of looking at the assets of the institution. And in fact, these are two of the first graduates from UD who went on to legal careers, I believe. And then the legacy is certainly what has happened since, the fear that HBCUs may become obsolete, and the fact that they still remain underfunded in most states in comparison to their contemporary PWI institutions.
So how did this case fold into the whole Brown collection of cases?
This case happened 4 years before Brown, and in fact, the Delaware cases from Brown were also argued by Lewis Redding in the Chancery Court in Delaware, sort of giving them the bona fides before they went to the Supreme Court to show that there was a clear violation of the separate but equal clause as envisioned in Plessy.
And this was it a 1950? Is that what you said, the 1950 case?
It was a 1950 case.
Yeah, so Brown out of Kansas, is that a 51 case, or?
I think it's a 54. Brown is decided in 54, but there were 5 other companion cases, including the Delaware cases. Right.
Yeah, I'm trying to figure out like
5 total companion.
Trying to figure out what the chronology is there of those 5 coming together. The Brown case decided in 54, but I know the Virginia case is coming out of 51, I think. So they all come together. Now, I just want to close with this. So you're a lawyer,
right.
You know,
sometimes.
Kimeu, and sometimes, well, and you come from some family members who are lawyers. And so do you feel any, like, is there anything particularly like when you look at this case, because you work in Delaware at Delaware State, does this case hold a higher significance in your mind than maybe it would just in the general legal community because of your connection to the
I would say yes. One, because the sort of strategy that Attorney Redding used to go to the Chancery Court to look at it from an equity standpoint versus purely a constitutional standpoint, even though it was a constitutional issue being argued. But also the fact that we've come a long way, but we still have a long way to go. Justice Seitz' son, Colin Seitz Jr., is our Chief Justice, and he's done a lot of programming on our campus. And so, yeah, it does hold some significance in that regard.
Oh, that's really awesome. His son, which is problematic on one hand because of the dynasty element, but is on the other hand, to have him be connected to you all is great.
Correct.
Well, Dr. Kimeu, thank you so much for your time, for getting up early, for spending this with us. And we definitely are looking forward to seeing you again in the near future.
Thank you, David. I appreciate you.
Yeah, thank you so much. Good day. Have a great day.